in this module, we'll be looking at the question of what is an administrative decision, and this is the fundamental foundation of administrative law. What is it that administrative law acts on, and how do we define it, and more importantly, what's excluded from that? Now, this is probably one of the more traditionally law-like topics that we're going to be looking at this term, because it's all about sort of those definitions and the edge cases and what happens when someone challenges and that sort of thing. And what we'll find throughout the rest of the term is that a lot of administrative law, particularly when we look at merits review, doesn't really have a lot of that conventional legal character to it. And you might find that a bit surprising. And some people kind of bounce off it at that point and sort of find it a little different to what they're used to. And I don't think that's helped by the textbook, because the textbook tries to kind of reinvent admin law from a legal viewpoint. Whereas the truth is admin law is actually, in practice, doesn't really involve a whole lot of law. In practice, we could probably finish at about week 4 and go home, really. And the rest of the term is what we're required to teach under the Priestley 11 accreditation requirements. So there's a good reason why we're looking at all that in depth. It's because your accreditation as a practicing lawyer depends on it. But bringing it back to that practicality, which I think is always really important, because I think that's where people do get sort of a little bit adrift at times, because they're thinking, well, why are we studying this? Why are we doing it? So I'm going to try and really bring us back to that. And as I said, practically admin law doesn't even involve very much law in everyday practice. Mostly it's about negotiation, it's about tribunals, it's about telling stories in certain ways to protect the interests of your client or your organisation or whatever. But the old-fashioned, let's look at cases and let's look at split the difference on this and that doesn't happen that much in real administrative law. So let's have a quick forecast about what we're going to look at this term, and let's see how this question, this basic question we're going to look at this week, how that fits into all of that. All right, so this first week, I mentioned last week, there's the pyramid of administrative law. There's the old judicial review, which is not used very much anymore, except where we can't get away from using it. There's the new administrative law, which is 50 years old, but it's that tribunal-based merits review. And then the base is that foundation of other laws and other legal systems that protect those other two systems and help, like freedom of information, that help those others function. Now, the question we're looking at this week about what is a decision is relevant to both judicial review and administrative and the merits review forms of administrative law. Because it is fundamentally the way in which government departments try to weasel out of being accountable. So most of the legal actions happened here is about jurisdiction, and it's happened where someone has challenged the government about a decision they've made, and the government's tried to wriggle out of it by saying, oh, look, it's not really an administrative decision, it's something else. And the case law that exists here, and as I said before, this is a fairly unusual area in that there is more cases, is about setting that jurisdictional boundary. So cases, they're not terribly enlightening or necessarily very challenging or even all that interesting, but they do give us some principles that we can use to give us that border, that first question about, is this something that admin law applies to? Now, there is a policy element to this, in that the lawmakers don't want administrative law to apply to everything. They want it to only apply to substantive things. So we'll find as we go where the borderline tends to fall is we don't want to, every time the government changes its, the carpet in its office, we don't want people filing administrative review to say we want a different coloured carpet in the office or anything like that. We don't want all this trivial stuff that's around and about what government does, which makes sense. But on the other hand, we've also got we've got governments, not just the current government, successive governments who are constantly saying, oh, none of this stuff is reviewable because of this or because of this, because it's not really an administrative decision, and the court's constantly intervening and saying, well, no, it actually is a decision. You actually do have to be reviewed here. So the thresholds are slightly different for merits review and judicial review. Merits review is a little more open. Judicial review has a lot more conventional case law about, jurisdiction that goes back to the old common law system. And today we'll also be looking at the legislation around judicial review, which is the Administrative Decision Judicial Review Act. Just a quick reason why we're looking at that is that was a codification of the common law at the Commonwealth government level. So we'll be talking a little bit about the ADJR Act today, and it applies only to judicial review, and there are versions for all the state judicial review regimes, but it was originally just a Commonwealth law, and what it was done is to codify the common law. So we've even got less reliance on cases here because we've got an act which codifies what a lot of the cases said. But of course, textbook writers being what they are, they like to say, oh, the act says this, but here's what it replicates. Here's the old common law that you don't need to know, but we need to pad out our page count by putting these things in there. Or that's probably not very generous. It's probably, well, our original version of the book that we wrote 20 years ago had this in it, and we don't want to take it out, so we'll just keep adding more stuff in. And, I'm sure you see that a lot, that law textbooks are not great at editing, and they tend to leave stuff in, and you think, haven't we covered this somewhere else? And it's usually the case. It's just that for whatever reason, the genre of the law textbook is about stuffing more content in rather than giving a cohesive overview. But preaching to the choir here, I'm sure. Coming back to how this all fits together. So this week we're looking at that threshold question. Is it a decision or isn't it a decision? We'll look at the rules around that. They're not very hard. It won't take long to go through those. Then over the what are we doing in week 2? Over the next 3 weeks, in modules 3, 4 and 5 is looking at those 3 sides of the pyramid of admin law. So the first thing we'll look at is those foundations. We'll look at things like freedom of information, privacy law, ombudsman, the things that create the environment in which an administrative law lives and operates and support its operation. And a clear example of that is the law that requires decision makers to give a decision, to give a reason for a decision. Under the common law, it was really hard to actually challenge a decision when a decision maker said, well, I'm not telling you why I made it. So we have a law that says, well, if you make a decision, you've got to give the reasons for it. So that's just one example of this whole ecology of supporting laws that are designed to make the system better, okay, to make the governmental system better, but also to provide tools to support both judicial review and merits review. So the week after that, we'll look at merits review, which is pretty much where, if you were looking at practice, where we could end. That's pretty much all of what administrative law is. And then we'll look at judicial review, which doesn't happen very often, and it only happens where things have really been excluded from merits review for whatever reason. So that's the first 5 weeks, I think, of the course. And from there on in, we're just basically going through all the different elements of judicial review and all the different reasons, whether it be unfairness, unreasonableness, bias, or whatever. We'll be looking at those one by one, week to week, and it's kind of like, in some ways, I think people who struggle in admin struggle at the start, and once you get all that core information in your head, it's kind of like a bit of a downhill glide after that. I mean, there's all sorts of principles and cases and things to talk about in those weeks, but it's very much, for the last sort of 6 weeks or so, it's pretty much just going through those different principles and different examples of them. So as long as you get the first part right, and this is where it's really important to ask questions in the workshops where there are things that aren't clear or you need to know more about, because getting that first bit right is the key. And then we sort of follow down to the end of the term. And then the last week we look at prerogative writs, primarily because it's a priestly 11 area that we have to cover. So we're just going to do those at the end. This is an interesting area. I mean, this is probably something you can skip forward for if you don't care, but as a legal educator, this is one area where the Priestley 11 rules are really out of step with practice for various reasons. As I said, literally for work and admin law, you could just do the first 4 weeks of this and walk away. The rest of it is really not all that relevant. But the rules say we have to teach all this stuff. Why is that? Well, one of them is the rules are 30 years old, and the rules were created by people who were educated under the pre-merits review system. So consciously or unconsciously, there's a bias towards the old common law system, the old system that isn't really used anymore. But there is still this sense of, well, this new fandangled administrative law system that's merits review based, it probably won't last. So we still have to teach the old stuff just in case, that all goes by the by. So there is that too. But I also think what is interesting is, I mentioned earlier that there's not that much law in actual administrative law. Legal education is based on, and textbooks that are created for legal education are based on a very set way of approaching the law, which has kind of not that close a relationship to practice. So it's all about textual analysis, it's about cases and precedents and so on, and high court decisions and stuff that people in practice never really deal with. Now, I'm not saying that that's irrelevant, and I think it's interesting to watch how common law develops and everything else, but I am acknowledging that it is out of step with what lawyers do in the field, and this is one of the primary areas in which legal education is not a practical form of education. It's about understanding legal discourse and legal texts. Now, there's a whole story that I won't bore you with now as to where that all comes from, and a lot of it is because law is pretty much a new kid on the block academically, and when they created legal education, most of the people who were creating it had things like divinity degrees, religious degrees, and they went back to sort of religious studies as a way of teaching law rather than a practical way. So law was originally an apprenticeship style system, and then it became university based, and they said, well, how are we going to assess something practical? Let's not bother with practicality. Let's do this biblical style textual analysis. And even if you look at like the law books, the law reports and statute books, they have a very sort of biblical quality to them. And I realise as I'm saying this that you guys probably haven't ever seen them, that you're educated in the era of electronic resources. But if you go to a law library, there's this kind of weight of biblical authority around the book, the text, the case. So what that means practically for us is that a lot of legal education was based around this sort of textual analysis. What is the authority, and what does the authority mean when this and this is said, rather than testing people's ability to actually do stuff, to actually do the advocacy, and in this unit where we're branching out into the idea of systems development and building and creating administrative systems. None of that is part of the core of legal education. None of that is core to the system of thinking that's created your textbooks, which spends not very much time talking about what you do as an administrative lawyer, but talking a lot about very pedantic issues in legal interpretation, because that's the way we see we can assess students. We can set an exam and say, what does Justice blah blah's opinion in this say? It's much harder to assess a student to say, how can you be an effective administrative lawyer? So that's been a long day trip to unnecessary land, and hopefully if you've been bored by that, you've skipped ahead to this point where we're coming back to that question of what is a decision. Because, as I said, there's some very simple propositions here as to what is or isn't a decision, and yet we fill pages and pages and pages of study notes and textbooks about the kind of edge cases where people had those kind of sort of strokey beard meetings and thought, well, what is this? What does this actually mean? But at the end of the day, it is not that hard. All right, so let's cut to the chase. What we need is basically 4 elements. There needs to be a decision. A decision has to be a decision. I'm going to come back to these. 2 is it needs to have an administrative character. 3 is it needs to be under an enactment. And 4 is it needs to not be excluded by various laws that say that they can't be reviewed. I'll look at each of those in depth, but basically if you keep those 4 things in mind, it'll help you understand whether something is in or out of the system. Now, most of the cases where people have a grievance, most of these will be pretty clear. So this is not something that we'll look at it in the workshop, but I can't really see setting an exam question on it. But again, it's that fundamental issue that you need to know. And what I'm going to transition to in the last part of this video is talking about the robo-debt crisis. And what's emerging is, I guess, a fraying of the edges of this idea of what a decision is as we start automating more things, and people are talking about, well, we'll let AI run everything and that'll be great. And a lot of whatever assumptions that are made here start looking very different when we start having things like people saying that the NDIS system, I will just let AIs decide is eligible or not. So I want to keep those things in mind while we're talking about this, that what's currently a fairly stale set of sort of very legalistic principles will becoming more and more important the more and more this sort of automation and AI is applied. Alright, let's come back to those and look at those in a little bit more depth. First of all, in terms of these rules, you'll see reference in the text that the courts admit that these are all really inconsistent. So even within the common law, they're saying, oh, the rules here seem to be really inconsistently applied to all cases, so that's fun. And also there is a little bit of a difference between the old judicial review and the merits review, and a sense that the merits review is a little bit broader as to what's a decision and what isn't. But again, we don't have very clear, statements on this stuff. So the first issue is whether it's a decision or not. And there are a couple of parts to that. The first is that it's a decision has to be something that's final or reasonably final, and the second is it has to be substantive. It has to be something that's meaningful and not trivial. So in terms of being final, a decision has to be either final or a stage in the decision-making process for it to be reviewable. So if someone is saying, I'm thinking about making a decision and this is the kind of thing I'm thinking about, that's not reviewable. And that's, I guess, practical and sensible, because the courts want to actually get something that's comprehensible to review. So if you say that, the local council's thinking of doing this and making a decision around this, I want to review it, they say, well, wait until they've made the decision, don't yelp until you've been bit. Wait until there is a final decision and review it. That being said, there is the notion of stages of review. So it doesn't have to be the final end of the day decision. And we do comprehend that some decisions happen in a series of decisions. So you get to a point where there's a decision and that leads on to another decision. But yeah, things that are not yet ripe, I think is the term they use. It's like picking a piece of fruit that's not yet ripe, are not considered decisions. Now the second part of that principle is it has to be substantial. A substantial determination. So the example I gave earlier about, sort of trivial things like they're making a decision about refurbishing their offices or whatever, that's not really affecting your rights, and that's not really shaping your interests. That's something that's not substantial. Some of the examples that are given, particularly I think in Bond's case, situations where parts of other processes are not seen as substantial. So in one of the cases, someone applied for, there was a decision made as to when a hearing was to be heard, and someone appealed against that, and the court said that that wasn't a substantial decision. That was just a part of the procedure that was along the way. But then we have other discussions in the commentators and in other cases where they say, well, sometimes something is procedural could end up being substantial. So it's a little frustrating here that there's a lot of fidgy-widginess in the middle. But usually we'll have a common sense appreciation. If someone says, we're going to hold the proceedings on a Tuesday, and someone appeals and says, I don't want to go to court on a Tuesday, I don't like Tuesdays, obviously not a substantial decision. But if someone says, we're not going to hold the hearing, we're not going to hold the proceedings for 3 years, then that's a substantial decision, because that's actually changing the whole character of the decision and the way it's going to be reviewed. So yeah, there's a lot of wiggle room in between the stuff that's just merely procedural, that's not substantive, and what actually substantially affects someone's rights. So that's the first thing. That's the first element, which is what's a decision. Second is that it is of administrative character, which is usually defined as being neither legislative nor judicial. And we go to the visa case here, which is a very important one in this area. And what the general, we tend to know what judicial decisions are because they're made by judges in court, so that's okay. We know that's things like the Boilermakers case aside, that's not such a big deal. But where we do get that overlap, particularly we've got the Westminster system where we've got that overlap between legislature and executive is what is a legislative decision and what is an executive decision. Now, what the courts have said in the visa case is that it's about the application of law rather than the setting of the rules. So someone setting up a set of rules is considered to be more of a legislative character, but someone applying the rules to an individual with a result is considered to be of administrative character or executive character. Again, we then follow that up by going, sometimes it's not quite clear. But let's not dwell too much on that at the moment, because there already is a risk this early in the course of losing people in those sort of legally pedantic-y theoretical debates. But let's just keep that distinction, with that keeping in the back of your brain that sometimes it's not that clear. But most of the time, if it's just about, well, this is our new policy going forward, that is not reviewable by judicial review or merits review. But if you say, this is our new policy and that means this is going to impact on you, that's considered to have the administrative character. The third element is that it's under an enactment. So where this usually gets into trouble, where decisions are usually not considered to be executive, is where they come under things like private law. So if you hire someone as a government department and there's a conflict over the work employment, then that's actually a private law, employment law situation, not an administrative law decision. Although, it does overlap, that you're an administrator making a decision over the people who work for you, but the source of the conflict is in employment law, and is in private law, or is in contract, or whatever. It's not in the legislative scheme. So there's situations of cases where someone who's hired by university sacks them, they sue for they have a choice of suing for wrongful dismissal or taking administrative review over the decision to sack them. In those cases, the courts say, well, yeah, the university gets its power under an enactment, but the actual decision actually comes under the work contract. It relates to the work contract, and it relates to labour law, employment law, private law. It doesn't apply to the public law that set up the organisation. So that's something to think about. And this is, again, one of those areas where governments try to weasel out of things and say, oh, we actually had a contract with an external person, and this is actually private law, and so not subject to administrative review. But it's not generally treated very favourably by the courts when they do that. They tend to take a pretty strict look. But just bear that in mind, that admin law, it doesn't substitute just because you're a public authority if there's another area of law that's the basis. And again, that's more important for judicial review than merits review, because merits review is more broad in operation. But we will come to that shortly. And the fourth element is that it's not excluded. A decision is not excluded. So there's a whole lot of decisions that were excluded from review by the original Judicial Review Act, and every year each government adds more to it. So originally it was just things like ASIO and law enforcement, and only like the confidential parts of those operations that were basically said, well, you can't go to ASIO and, you know, review the decisions about what spies they're chasing, or, you know, or whatever, or the federal police decision to prosecute someone, or those sorts of things. So initially there was this very small number of limitations, but over the years successive governments have gone more and more secrecy minded, and I'll post some news reports as we go through the term, because the Albanese government has become a particular focus of this, the secretive way in which they operate. Not being partisan here, because the kids is not like the coalition were any better, but I do think it's important to point out that one of the foundation ideas of admin law is you can't trust any government, and they need to be constantly kept under surveillance by the citizens to make sure they're not trying to wriggle out of their responsibilities. So there we go. There's those 4 rules. Has to be a decision, which means it has to be a final decision, and has to be consequential, has to be substantive. Second, it has to be an administrative character. It's not something that's about making rules or policy, it's about applying it. 3 is it's under an enactment, it's not under another area of law. And 4 is that it has to not be excluded, which always means checking for judicial review, checking the legislation to see if there's in the appendix if it's been excluded, and in merits review only things that are reviewed under the legislation are able to be reviewed. So you have to check whether there hasn't been a repeal of that appeal line. Anyway, those things will make more sense when we come to look at those 2 areas of review in more detail. I just want to mention it there. Now, the last thing I want to mention is some of the changes to administrative and bureaucratic culture that we've been going through. We've seen more and more use of administrative powers, more and more use of executive powers. In the United States, we've seen the massive use of executive orders. I mean, Trump has been very, very clear examples of the use of those. But, you know, Biden and Obama in particular used those a lot to circumvent democratic action. And even in our government that's on the Westminster system, we're increasingly seeing governments try and rely on executive privilege and try and rely on non-democratic ways of taking action. Now, those things are generally subject to administrative review, but we're also seeing governments that are increasingly secretive about those. So we are seeing substantive changes in culture at the top end, with more and more move towards trying to make non-accountable decisions by government. Donald Trump, not being political about this, but is a very clear example of what happens when that goes completely outside of the cultural norms. But we are facing the same sort of things happening here, just not on that scale. The other thing we're happening at the bureaucratic scale is this increase in push for automation and an increase towards now, well, if we're going to automate, then we can use AIs to make decisions and take human decision makers out of that. There are substantive problems with that, largely because of the lack of open and accountability. Now, I've referred you to some videos this week, and I'll link them in Moodle so that it'll be easier to access, but they're also in the study guide around the robo-debt crisis that unfolded over multiple years. And that was where a government system to review people's social security debts and to check them against their tax debts and to say, here are situations in which they might need to be reviewed, basically got mechanised into a very, eventually there was a Royal Commission, and the Commissioner was really clear about how cruel and non-democratic the application was. But basically, it was this system that got completely out of control, was not reviewed, was not reviewable. The government knew it was illegal fairly early on, suppressed the information, lied about the fact that it was illegal, lied about the fact they knew it was illegal, tried to mislead the Royal Commission. Of anything, this is an area that I think, and we will come back to as an example throughout the term, but it has everything, practically every area of admin law that could go wrong in it. So I've linked a series of videos by a citizen journalist, which are actually the best. I've tried to look at sort of media ones, and they're not so great. I've listed a series of videos on the Robodebt situation, and it's something that we will talk about because it's not going away. And the latest scandals involving using AI to determine NDIS applications is an example that the government has learned nothing from the previous government's struggle with Robodebt, that they're just running full tilt at this automation. And to tie all that back to the theme of this week, we've got that fundamental question of what is an administrative decision? Is it something that needs to be made by a person? Well, it needs to be accountable, it needs to be open, it needs to be something where people understand the reasoning and they understand the reasons for the decision. And as things get locked in sort of the black box of automated decision making, that becomes less and less accessible to people to actually be able to understand, interrogate, and for our purposes challenge where it's gone wrong. So we'll come back to that, but for this week, let's just focus on, when we come back to workshops, we'll come back to that idea of, what is a decision. We'll run through those terms again, make sure we're clear about it, and then in the B side, we're going to start talking about the idea of what it is to be a lawyer who doesn't necessarily advocate on behalf of a client, but actually builds systems that are consistent with the law. And in admin law, there's a really clear and obvious example of the situation where, there's a lot of need, clearly from the scandals the government's facing, for people who are informed with admin law to make sure that when you create a new system, when you create a governmental system, when you create an organisation, that it is something that is consistent with the law. Okay, so hopefully that wasn't all too overwhelming this week. I know, like I said, this is the point at which a lot of people bounce off of admin law is at the beginning. So have a look at the stuff in the textbook. Skim read it where you need to, because there's a lot of kind of pedantic detail in there. But we'll be talking about it again in workshops. That's the point, to make sure that we're all on the same page here, so that we have the foundations of what we know about to build on as we go forward.